Thank you all for joining us this afternoon. Today we're here to talk about something that has been in the headlines a lot over the last year, the use of the National Guard for public safety and domestic security. Up until a year ago, most Americans had never even heard of the Posse Comitatus Act, but it has now become kind of a central part in this debate over the use of the National Guard for those reasons. My name is Lisel Pettis. I'm the Policy Director for Criminal Justice and Civil Liberties at the R Street Institute. I have been joined by Joseph Nunn, who is counsel in the Brennan Center's Liberty and National Security Program, and Kevin McMahon, who's the Assistant Secretary of State for the state of Washington. Our goal today is not to take a stance on the use of the National Guard, but rather really give clarity to the laws around the use, what history has taught us about the use, and the trends that we have seen. We're really aiming to cut through some of the confusion, as well as give kind of a clear picture going forward of what we may expect. I do want to note that there's been some handouts that have been put out onto your tables during that break. They really just kind of summarize some of what you're about to hear from Joseph Nunn about the law and the legal framework around the use of the National Guard. We wanted to start with just making sure that we all have a basic understanding of the laws, and then that summary sheet will hopefully help guide you if you have any questions as we go into the actual panel discussion. And then we will be ending with a question and answer. Like I said, this is not meant to be a political panel by any means, but we will answer your questions to the best of our ability based upon the laws and the policies out there at this point in time, as well as practical experience that you'll hear about. So I'm actually going to turn it over to Joseph. He has done extensive research on the laws governing the domestic deployment of the National Guard, so I'll give it to him.
Thank you, Lisel, and thanks to all of you for having us. So my goal here is to just take about 10 minutes to walk through the law on the subject. For a lot of the folks here, I think this information is not going to be anything new, or at least parts of it, but my hope is to bring us all up to the same baseline so we can have a conversation. So I'm going to start by talking a little bit about the National Guard itself. As most of you know, the National Guard is the modern incarnation of the state militias contemplated in the Constitution. It is organized at the state and territorial level, but it is largely funded by the federal government and largely governed by federal law. That said, the Guard operates by default under the command and control of its state or territorial governor. However, under certain circumstances determined by Congress, the president can federalize, call into federal service the National Guard. When federalized, the National Guard becomes, for all intents and purposes, part of the active duty armed forces. There's no legal distinction between a federalized National Guardsman and an active duty member of the Army. Federalization is binary. It's an on-off switch. The Guard is either federalized or it isn't. It cannot be quasi-federalized. It cannot be federalized for some purposes but not others. That said, the Guard has three different duty statuses. The first of these is state active duty status, where they're under state command and control. They're carrying out a state mission, funded with state money, receiving state benefits. Everything is state. On the opposite end of the spectrum, we have Title X status. This is federalization, where the Guard is they come under federal command and control. They're carrying out a federal mission governed by federal law, receiving federal pay and benefits. Everything is federal. This federal mission could include up to going overseas to fight in a war. In the middle, we have something called Title 32 status, where the Guard remains under state command and control. They have not been federalized, but they receive federal funding and federal benefits, which matters a lot to them, and they can be used for federal missions at the request of the President or Secretary of Defense. The reason this matters so much, all of this matters, is because of the Posse Comitatus Act that Lisel mentioned just a moment ago. The Posse Comitatus Act is the most important restriction on the domestic activities of the United States Armed Forces. It bars the federal armed forces from participating in law enforcement, from executing the law, unless doing so has been expressly authorized by Congress. Now, there's a few important pieces of that. The first is that the Posse Comitatus Act, which I'm going to call the PCA from now on, applies only to the federal armed forces. That means it only applies to the National Guard when they have been federalized, when they've been called into federal service. Otherwise, it does not bind what, say, a governor can do with their National Guard under state law. The second important component is that it only applies to law enforcement activities. The PCA is unconcerned with any activity that the military undertakes if it's not law enforcement. What exactly law enforcement is kind of a fuzzy concept within the law, but arrests, searches and seizures, these things are undoubtedly law enforcement. Generally, any situation where the Guard is likely to be laying hands on people, or there's a significant possibility of them actually having a face-to-face confrontation with civilians, that's going to generally fall into the realm of law enforcement. On the flip side, activities that don't involve that kind of face-to-face interaction, even if they may form a sort of integral component of a broader law enforcement operation, are probably not law enforcement for the purposes of the Pascom-Thomas Act. And then the third thing that's important to understand, oh, there it is. Incredible. He's going to control. Okay, could I get 2 more slides? One more? There we go. Is that there are exceptions. The Pascom-Thomas Act, in its text, refers to potential constitutional exceptions. My view of the law is that there are none. However, there are a number of statutory exceptions. The most important of these is the Insurrection Act, which I'll talk about more in a moment. Could I get the next slide, please? So next, I'm going to go through some important authorities for using the Guard. The first one I want to talk about, unfortunately, does not have a nice, neat name. It's 32 U.S. Code Section 502F2A. This authority authorizes state governors to deploy their Guard in Title 32 status to support operations or missions at the request of the President or Secretary of Defense. This is a very broad authority. The statute doesn't clearly define what it can or cannot be used for, but there are some significant limitations. The first is that it's voluntary. A governor can refuse a request from the president made under Section 502F. They can say no. In addition, a state may never deploy its unfederalized National Guard forces into a non-consenting state. That's because U.S. states are sovereign entities, and their sovereignty is co-equal and territorially limited. Indiana is not more sovereign than Illinois, and vice versa. And Indiana's governmental authority stops at the Illinois state line. For the same reason that Illinois cannot reach into Indiana and sort of exercise governmental power there, Indiana cannot send its unfederalized National Guard into Illinois without Illinois' consent. In addition, National Guard forces operating in Title 32 status are subject to state law, including any state laws that might restrict the activity of those forces in various contexts. Next slide, please. So, the Insurrection Act. Like I said, this is the most important exception to the Pascom-Thomas Act. Oh, I should note here, 502F is not an exception to the Pascom-Thomas Act, but it doesn't need to be, because since the Guard is not federalized, they're not subject to the Pascom-Thomas Act. So, the Insurrection Act, it authorizes the president to deploy the active duty armed forces and or federalized National Guard personnel to suppress insurrections, execute the law, or protect constitutional rights when state authorities are unable or unwilling to do so. The Insurrection Act is an old law. It's often called the Insurrection Act of 1807, but it's really an amalgamation of statutes enacted between 1792 and 1871. The original intent behind the law was narrow, but its language today is broad, vague, and archaic. The Insurrection Act has not been substantively amended at all since 1874. And it does grant wide discretion to the president. There's no question about that. One open question is whether an invocation of the Insurrection Act is subject to judicial review. In a decision from 1827 called Martin v. Mott, the Supreme Court suggested that a president's decision to invoke the Insurrection Act is conclusive, that it's not subject to judicial review. Martin today has to be interpreted very carefully. For starters, it's a very old case. While the Insurrection Act has not changed in a long time, it has changed significantly since 1827. It's a very different law than it was back then. Our broader understanding of constitutional law has changed significantly. Martin also involved a peculiar set of facts that I'm not going to go into detail on right now, but suffice to say, it involved a enlisted member of the military challenging invocation of the Insurrection Act, which is a very different fact pattern from a state challenging invocation of the Insurrection Act and seeking injunctive relief rather than essentially relief from a court-martial conviction. In addition, later cases, most importantly a case called Sterling v. Constantin, have suggested that even if Martin is still good law, even if there is this Martin rule, that there's a good faith exception. And that also there is what the court described as a permitted range of honest judgment, a sort of zone of military discretion, that if the president strays outside of that the courts could weigh in. What's more, even if it's the case that an invocation of the Insurrection Act is itself not subject to judicial review, anything that the military does once deployed absolutely is. Invoking the Insurrection Act does not allow the military to violate federal law, violate the Constitution, any of that. Let's see, I think, next slide, please. So the last authority I want to talk about is 10 U.S. Code, Section 12406. A law that virtually no one was paying any attention to a year ago. 12406 authorizes the president to federalize National Guard personnel when either the U.S. is invaded or in danger of invasion, when there is a rebellion or danger of a rebellion against the authority of the United States government, or when the president is unable with the regular forces to execute the laws of the United States. Historically, Section 12406 has been understood to be a very narrow and sort of technical statute that does nothing more than federalize the National Guard, but it was not understood as being a freestanding deployment authority. But 12406 is very poorly drafted, and there actually isn't a way to interpret the law that entirely makes sense within the statutory scheme. It is largely sort of redundant with the Insurrection Act or conflicting with the Insurrection Act depending on how you interpret it. But there's no real way to sort of square the circle. Now, over the course of the past year, the Trump administration made sort of unprecedented use of this authority to unilaterally federalize and deploy National Guard personnel to 3 cities, Los Angeles, Portland, and Chicago. This resulted in litigation, which was the first time we've seen sort of any real litigation over this statute. There's exactly 0 case law on 12406 prior to June of 2025. Ultimately, one portion of the Illinois case made its way in front of the Supreme Court. So next slide, please. And in late December, we got a written order in Trump v. Illinois, where the court found by a vote of 6-3 that a few things. First, that the term regular forces in Section 12406, paragraph 3, refers to the active duty armed forces and not to federal law enforcement agencies. Second, that for the president to conclude that he is unable with the regular forces to execute the law, it must first be lawful to use the regular forces for law enforcement under the circumstances at issue. That is to say, an exception to the Pascom-Thomas Act must apply. And third, that the government cannot claim both that operations under the so-called protective power, which is a sort of separate legal theory that I haven't had time to dive into here, do not constitute law enforcement for the purposes of the Pascom-Thomas Act, and that this power, this so-called protective power, authorizes federal military participation in law enforcement for the purposes of triggering Section 12406, paragraph 3. What that amounts to is the government could not argue both that deployments to protect federal personnel, property, and functions aren't law enforcement, but authorize law enforcement. They can't say that it's both of those things at the same time. Now, shortly after this this decision, the administration announced that it was demobilizing the National Guard personnel that had been federalized and sent to those 3 cities. The upshot as a legal matter is that 12406 has essentially been taken off the table for now. Because of the court's ruling, if a president wants to unilaterally federalize and deploy National Guard personnel now, he will likely need to use the Insurrection Act. I realize I skipped over one element of the Insurrection Act, and then I will turn it back over to Lisel, which is that the law is, as I mentioned, very broad, but both historical practice and past institutional interpretation suggest that it's not as broad as it appears on its face. That use of the Insurrection Act is appropriate in basically 4 circumstances. One, when there's been a state request for assistance, such as during the Los Angeles riots in 1992. 2, if there is a rebellion against the authority of the United States government. That is basically a category of 1. That's the Civil War. I think there's a question of whether even something like the Whiskey Rebellion really qualifies as a true rebellion against the government in an attempt to throw off its authority. The third is either 3 or 4 buckets, depending on how we look at it. But in both cases, we're talking about unilateral invocations of the Insurrection Act to execute the law. So there's no rebellion, and there's also no state request for assistance. Historically, what we have seen is that presidents have only done that when there has been a federal court order that is being flouted, that state authorities are either unable or unwilling to stop private action, private violence from sort of defeating the jurisdiction of the federal courts. And if we look particularly at the past sort of 130 years, not only do we see that generally only happens when there's a court order, but it generally only happens in the civil rights enforcement context, where and that matters as a legal matter because it means that the federal government is exercising its authorities under the 14th Amendment and the Reconstruction Amendments more broadly. And the federal government has much broader authority to act unilaterally and much more robust authority when operating under those amendments than it does in most other contexts. So the upshot is, generally speaking, if the president wants to invoke the Insurrection Act unilaterally for the purposes of law enforcement, there almost undoubtedly, I would say, needs to be a federal court order that is being flouted, that is going unenforced. And there's a strong argument that it also needs to be in the context of civil rights enforcement. So I will stop there and kick it back over to Lisel.
I'd like to ask first, I imagine that we have several National Guard, either current or former individuals that served in the National Guard. Can I just get some hands of who has served in the National Guard or currently does? Okay, actually less than I thought. So this may actually be newer to people than I may have thought, at least. I wanted to just kind of summarize that in the grand scheme of things, there's kind of 3 ways that the National Guard can be deployed. The state is requesting it, and it's under state authority. The state is working in collaboration with federal administrations for that deployment. So it's a federal deployment, but with the state really doing it in collaboration. Or it's a federal deployment, and that's really done by the feds. And where it's really become different over the last year, and Joseph really started to already go into this answer, but I will ask it to him again just for clarification, is that this is a time where it's been a federal deployment over the objection of the state governor, which has made it different and why it's been a little bit more in the news. And so, as you had pointed out, this is not the first time it has happened. This has happened in the past, maybe not in everybody's lifetime, but certainly plenty of people's lifetime. So I would ask you, what really does make this different? Why has this become such a big issue for people to discuss that's different than the Civil Rights era, or different than just the general use of the National Guard by a state governor?
Sure, thanks, Lisel. I think I would, first of all, you're absolutely right. It is, what we've seen over the last year is new. In the past, 130 years, we've seen the Insurrection Act be invoked unilaterally, so over the objections of a state governor, 5 times. And all 5 of those invocations came between 1957 and 1965. I'm referring here to the Insurrection Act because, again, there's no previous history of unilaterally federalizing the Guard and deploying troops outside of the Insurrection Act. So, and that would be the first kind of key difference that I would highlight that we saw over the past year is this use of Section 12406. And even acknowledging that the Supreme Court's decision sort of takes 12406 largely off the table, the court's implicit recognition, both the Supreme Court and the lower court's recognition, that 12406 is a freestanding deployment authority, which all of the courts reviewing these deployments more or less implicitly recognize. That is itself actually a massive shift in the law. That was not the general understanding of what that authority meant a year ago. So that would be the first difference. I would also look at 2 others. First, federalized National Guard and active duty personnel have never previously been used to assist in the interior of the country with immigration enforcement. That's a sort of a fundamentally just a new job for the military. And that matters in practice because it's not an area where the military necessarily has sort of institutional expertise or relevant training. And it requires sort of a shifting of resources and personnel to staff those operations. So that's likewise fundamentally new. And then the third key difference is the one that, as you said, I've already highlighted, which is that the fact that these deployments were unilateral is a really significant departure. And unilateral in a context where there was not a federal court order that was going unenforced, and outside of the context of civil rights enforcement. I think, the biggest takeaway looking at the past 250 years of federal domestic military operations is that in the overwhelming majority of cases, you see cooperation between federal and state and local authorities, that the states and the federal government are working together to respond to some situation. So that in itself is a really significant departure from how this has looked in the past.
So whether the Guard deployment is legal is one question, but certainly the other question is how does it work in practice? Legally, it will generally go to the courts after the deployment for that to kind of be worked out, but in the moment, there is still these practical implications that have to be worked out. And so, Kevin, you bring a very unique perspective, and that you've both served in the National Guard for, I think you said, 2 decades, as well as in a government leadership position. And so I'd love to chat with you just a little bit about how this works in practice. You have the Guard coming in under federal authority who may have a certain set of guidance. They're just there to do their job for their mission. But you may also have local or state actors who are there under different guidance to do their own kind of agenda. So given your experience, I'm going to start from the Guard side. What are kind of the realities of the legal decisions you have to make in the field? So how does the Guard member balance the federal, state, and community responsibilities?
Yeah, thank you, Lisel. That's a great question. And I will kind of, before I start, just to give you a little bit of background to understand some of the experiences that I've had. So as Lisel noted, I served full-time in the National Guard for over 20 years. And during that time, I had the honor of being the Director for Joint Operations. Many of your states and territories have this position, and they are the individuals that then help mobilize service members in response to fires, floods, hurricanes, snowstorms, kind of the typical things that you think that the National Guard is being mobilized for. And so I did that job for 3 years. Following that assignment, I was given a command of what's called the 10th Homeland Response Force for the 10th FEMA region, designed to respond in the event of a dirty bomb going off in a metropolitan city. So I had individuals that were trained to respond to that in support of the incident commander. Think a fire chief, a police chief, someone that is the incident commander for that area. And then in addition to that, because of that experience when COVID hit, I was asked to command what we call the Joint Task Force for the state of Washington's COVID response. So I was the incident commander for 18 months. In that time, we mobilized over 2,200 service members that served a period of 18 months in support of that mission. During that time, we had individuals that served both on state active duty, which Joseph talked a little bit about previously, along with Title 32-502F. And so a variety of statuses, and so status matters. And so to Lisel's first question is, one of the first things that you want to make sure that you understand from a practical standpoint is, what authorities are you working under? Because they matter. And so one of the key individuals that I would have on staff that would advise me is lawyers, right? Because lawyers are going to keep you out of trouble. They're going to be the ones that tell you the risk that you're taking if you attempt to do something that is not necessarily within the authorities that you have in that status. And so we worked through that and made sure that we were working in the intent of whatever status we were under, along with what was the intent of the governor or the incident commander. Some of the questions that I would ask as we were getting ready to mobilize individuals specifically for the COVID response, because we were getting requests from food banks because the elderly population that typically supports them were home because of COVID and they could no longer support it, but individuals still had the need for food. We were asked to support testing responsibilities, vaccination responsibilities, and I'll even talk a little bit later on about our support to our Employment Security Department. But with that, one of the first things that I would sit down and work with the individuals primarily out of our State Emergency Operations Center is, who's making the request? Is it the Department of Health? Is it the Department of Natural Resources? Is it local law enforcement? Because each of those have a different responsibility and a different impact as to why we're being mobilized. I would also ask, what assistance is being requested? Inevitably, someone would say, I just need a platoon or a company or some type of personnel to come to a mission, but what we really wanted to know is, what capability are you looking for? Because again, that matters as to the resources that we provide for that response. And then where and when, where will they work, and when do you need them? Because National Guard forces are not full-time. While we do have a full-time element that supports our traditional airmen and soldiers, those airmen and soldiers are a part of your communities. They have jobs, they have families, they have other commitments, and we cannot just immediately pull them into a response. In the state of Washington, where I'm more familiar with, it will take anywhere from 24 to 48 hours for those individuals to report, to go through a process to where we make sure that we have all their appropriate information so that we can pay them correctly, that we can notify their next of kin if something happens to them, if they're injured, and all those things take a period of time. And so we always set that expectation of, we're going to be there in about 24 to 48 hours, but what we would be able to push out to an incident commander or someone else asking for the support was a liaison officer. And that individual will get on the ground and begin to ask additional questions that maybe didn't quite come through the request and didn't come through some of the questions that we were asking for, so that when we got on site, we could immediately go to work. We also knew where we would bed down, where we would be fed, where we could park our vehicles, all those things as part of that collaborative effort that was really important for the success of the operation. And so those are many of the practical things that are taken into consideration from my standpoint. I realize that some of the incident commanders are like, hey, I need individuals like today, like in the next 6 hours. Again, we can provide some capability, but it's not going to be the full asset or package that we could push to them, and so those were a number of things that we had to take into consideration. With the current situation that we see across the United States, many of you out here are either law enforcement, emergency management, or some type of federal entity that might be requesting that support, and so those are some of the things to be prepared to respond to and be able to answer to the National Guard so that they can support you to do the mission that they've been asked to do. The other thing that I will highlight, and I kind of already mentioned it, but these service members are a part of your community. And so as we work through many of the incidences and the support that's requested, just know that they have families, jobs, and things that they eventually need to go back to. And I'll give you an example. With our task force for COVID response, Over the course of the 18 months, we distributed 98 million pounds of food throughout the state of Washington. Fabulous capability. And so as these food banks saw the capabilities that our service members could do for them, it became difficult for us to basically leave the mission. We had made ourselves so important that it was difficult for us to say it's time for the normal people that have been supporting this mission to take over, the ones that have been supporting you for years past. It's time for us to go home. And so we attempted many times to try to stand down that mission and received a variety of pushback because of the importance that others felt that it still held. We were able to continue to do that, but one of the things that you want to make sure is, what does success look like? At what point can you let that National Guard force go home because they need to go see their families, go back to their jobs, and then kind of get back to normalcy? And so those are many of the considerations from a practical standpoint that should be taken into consideration.
So I've spoken with several individuals who have served in the National Guard, and I've always been really impressed how they essentially could have given Joseph's presentation. They knew the law so well, because they really do have to understand under what authority they're being deployed and who they're reporting to, right? So I'm not surprised that that seems to hold true for you as well. But I want to go kind of more into your position from a government leadership standpoint. So I actually was on city council in Colorado during COVID as well, and so had that perspective of the collaboration it takes to get through some of these challenges. Certainly a very different challenge than what we're talking about today, which is more domestic security and public safety. But I know that you have also worked in your position with the Secretary of State with the National Guard when it comes in regards to elections. So if you could just tell us a little bit about your experience and maybe some of the things you've learned that have worked very well and what has not worked so well in that capacity that others could learn from.
Sure. So I retired out of the National Guard in 2022, and shortly thereafter, Secretary Hobbs asked me to come work for him. And then was appointed as the Assistant Secretary of State. So my portfolio, I have the privilege of managing our elections team, a team that does cybersecurity for our office, strategic messaging, and then civic engagement. And so some of the things that I took from my experiences within the National Guard when I started to work as the Assistant Secretary of State was an incident response plan. And so as we talked through elections and how that worked and cybersecurity response, realized that we had a pretty good cybersecurity response plan. We had a pretty good response plan as to how elections would work, but I wasn't so sure that they were nested and that they were mutually supporting. So one of the ways that we utilized the National Guard was we asked them to help us with a tabletop exercise where we sat down and we walked through, using them as facilitators, what is the role? What is the responsibility of the director? What is the responsibility of me as the Assistant Secretary of State? What is Secretary Hobbs' responsibility as the Secretary? And it was very informative and enlightening for us to go through that because there was a lot of assumptions that staff made. Give an example. The staff assumed that I, as the Assistant Secretary of State, was the release authority for many of the decisions. And what we had to do was correct the various directors to say, no. The decision authority rests with the directors. You know the business of the office. You know your staff. You know individuals within the field. Therefore, you have the authority to make those decisions. Just make sure that myself and the secretary are informed as to what those decisions are, so as we start to get inquiries from the press or from the governor's office or from other state organizations, we can respond as to what that looks like. Since that event, since we did that incident response plan, our state has experienced 10 white powder events or biohazard threats, many of them hoaxes. The most recent one was on 10 February 2026, just a couple weeks ago. We've also responded to two vendor outages. The CrowdStrike incident, right, which caused some issues within networks. That's a vendor experience that we also had the privilege and ability to respond to. In addition to that, we have had one ransomware event at a county that we assisted that county in their efforts to respond. And then we also had the Dropbox attacks in Clark County that some of you might be familiar with, but if you're not, an individual put an incendiary device on one of our Dropboxes. In the state of Washington, we are all vote by mail state. 60% of our ballots come to us via drop boxes for the counties to process. An individual put an incendiary device on one of those boxes on October 8th of 2024, and unfortunately the device didn't do really any damage. On October 28th, though, that same individual came back and put another device on not only a drop box in Clark County, but in Multnomah County near Portland. And in Clark County, it ended up destroying an undetermined number of ballots within that drop box because it burned through the metal and it destroyed many of the items that were inside it. We were able to respond in kind because of that incident response plan that we had. And I can talk a little bit more about the collaborative effort that incident also allowed us to work with different organizations. But the takeaway that I'm trying to give you is that using the National Guard and some of their capabilities can help you with your incident response plans, can help you with tabletop exercises, can be a second set of eyes just to make sure that your assumptions that you've made for whatever plans, whether it's coup, incident, doesn't matter. They can help facilitate many of those exercises for you so that you get a chance to make sure that your plans are going to work for you.
So I just want to clarify that in that case, it was the state calling in the Guard to work at that state level, correct?
Yeah, so we as the Office of the Secretary of State for the Incident Response Facilitation, asked the Guard to come support us. There's been other instances, so for example, with the Dropbox incident, the governor was concerned about copycat incidences throughout the state, and so he mobilized the National Guard, pre-positioned equipment and personnel so that if we did start to see additional Dropbox attacks in the state as we got closer to the election, that those resources were ready to respond quicker than that 24 to 40 hour timeline that I mentioned previously.
So something I want to go into real quick before we kind of go into future trends is kind of how differently the state deployments can work versus the federal deployments, and some of the assumptions that may be made that people don't understand the differences of. And so one thing I just kind of wanted to go into, when I was a prosecutor, one of the first things that was really eye-opening for me when I started working nationally on policy is how different every state operates in their prosecution. And so, Joseph, I'm going to turn it over to you real quick. We actually had a discussion just before this talking about whether or not a National Guardsman had the ability to arrest somebody or detain them. And I'll tell you, my assumption was they could not universally, and I found out I was wrong. And so could you just talk a little bit about, because I think it's very important for people to remember that the Guard does work differently state by state. But then again, just kind of also reiterate how that state authority may differ very differently than from any federal authority due to the Posse Comitatus Act.
Sure. Yes. So, what the Guard can and cannot do when it's under state command and control is a question of state law. There are essentially no sort of affirmative federal restrictions on what a governor can do with their National Guard when it's under state command and control. The governor can do whatever they want. The controlling factor is state law. So, for example, in Tennessee, the state constitution actually puts pretty significant limitations on what the governor can do with the National Guard. That's come up quite significantly in the litigation over the deployment to Memphis. But essentially the Tennessee law enumerates the situations that warrant using the Guard, whereas a lot of other states take an approach of just committing that question to the president's discretion. Similarly, states vary, as Lisel was saying, on whether the Guard has law enforcement powers and the scope of those law enforcement powers. So in Louisiana, for example, under state law, the default actually is that whenever the Guard is deployed, they are peace officers with the sort of full powers of a law enforcement officer, unless for that particular operation the governor has said that they aren't. So it's the default presumption that you see in many, if not most, states. It's not published yet, but in the next month or so, the Brennan Center is going to publish a compendium of every state and territory's laws related to the National Guard. So maybe I can send that around once it's published. But yeah, this is something that varies very widely from state to state.
And why it's so important for guardsmen to know whether or not they are being deployed under that state authority, which they may be able to work as a law enforcement officer, versus a federal authority, which they would have no right to do that. Is that correct?
Precisely, yeah. You need to understand, and your sort of guardsmen need to understand their authorities under state law versus their authorities under federal law, which are going to be much more consistent. As I mentioned during my presentation, federalized National Guardsmen are legally indistinguishable from active duty members of the armed forces. So they are barred from participating in law enforcement unless an exception to the Pasquim-Thomas Act applies. If there is an exception to the Pasquim-Thomas Act in play, they can participate in law enforcement, though because they are federal officers, exercising federal authority, they can't necessarily execute state law unless the state is asking them to. And the same is true of active duty military personnel deployed under the Insurrection Act, that they have the authority to execute federal law, not necessarily state law, unless the state is asking them to, and they've entered into an agreement for that purpose. I also notice, as a matter of practice, even when the Insurrection Act has been invoked, there are certain law enforcement duties that have typically not been assigned to military personnel. So this is usually sort of formal arrests, reading people their rights, actually sort of booking individuals. To draw a historical example, if you look at the invocation of the Insurrection Act and the deployment of paratroopers to Little Rock, Arkansas in 1957 to facilitate the desegregation of Little Rock Central High School, you had instances where the Guard detained essentially troublemakers, but did not arrest those people. They instead would just detain them temporarily and hand them over to the appropriate law enforcement agency. And in a lot of cases, that was actually the local law enforcement, because whatever the person had done was not a federal crime. It was whether a state or local offense.
Kevin, in your experience or in your perspective, do you have anything to add to kind of that change?
Yeah, so Joseph was talking about the importance of the Title 32 versus the state active duty, and I can give you a real-world example where the task force that I was commanding, supporting the COVID response, was at the same time where the protests related to the death of George Floyd were also taking place. And so we received a request at the state level for service members to come support local law enforcement in the greater Seattle area. So the state turned to my organization and said, we need you to take a bunch of individuals and get them ready to go to support local law enforcement. The issue was that they were all on Title 32 502F, which is a federal order. That's the status that they were in. So we had to take those individuals by name, remove them off of those orders, and place them on to what's called state active duty that Joseph mentioned earlier, because they were now going to be supporting law enforcement. And having them do that in that Title 32 502F status would have been complicated on a couple different levels, and so it was just determined to be easier to provide those resources in that state active duty status. That took a period of time, but we were able to then get those individuals up, support local law enforcement. And as Joseph noted in the debate or the conversation we were having previously, was in the state of Washington, National Guard will always be in support of. So they do not do arrests. They can assist law enforcement where if a police officer says, I want you to detain this person, they are then following the directions of that local law enforcement individual and they will detain them. But they cannot arrest. Only law enforcement within the state of Washington, from a National Guard perspective in the state of Washington, can make arrests. As Lisel noted, that's slightly different as you go from different states to states, but that's how Washington operates. what was it, about 5 days after mobilizing those service members to go up to support law enforcement, they came back to the task force to continue to support the COVID response, and we then had to move them again from state active duty onto that Title 32 502F so that they can continue to support the COVID response. And so that's going back to that comment I made earlier where the status that those service members are in really matters from a legality standpoint.
We have seen over the last year or two different states deploying to different areas in the nation, so I think that just adds to that complexity of knowing which laws are applying at the time. I'm going to kind of go into the future now. Knowing we do not have a crystal ball, I would like to just kind of talk through what we think we may see going forward. So I should just mention to you all that when we put this presentation together, this was before the Supreme Court had actually issued their ruling in December. So things have actually quite dramatically changed since that time, and it's given us a little more clarity. I wouldn't say a ton. So what we know now is that while we may not have official precedent for other jurisdictions from that Supreme Court case, it has at the very least told us that the judiciary is probably not going to just say there's a kind of this unfettered authority to the any White House administration to deploy the Guard, that they do feel like they may have oversight on these. And we do know that at least the current deployments, they likely are not going to be okay with under the laws that were considered this time around. Again, you've kind of said all the differences and what there may be, so that's where the question's going. But that the current arguments for those deployments in Illinois, which was very similar to what was in Portland, are not going to likely be okay with the courts. So can you just tell us, Joseph, with your crystal ball, what do we kind of think is going to be the potential legal authority after this? Do we have any ideas of what may or may not be allowed?
So I do have a few thoughts on this, though. I want to emphasize exactly what you emphasized, that none of us can predict the future, and it's very hard to say what's going to come next. I think we're not. I'm confident in saying that we're not going to see any more attempted deployments under Section 1246 by itself. I think I would also say, and you touched on this, and I would emphasize that this is sort of not a political statement, but just a sort of observation of intention. I think the Supreme Court was intentionally signaling discomfort to the administration, discomfort with these deployments, and indicating to them that they should sort of rein it in. And I think that's how the administration also themselves understood the decision in Trump v. Illinois, is that the court was not pleased with what it was seeing. I think if we see another domestic unilateral sort of federalization of the National Guard and deployment of the Guard and/or deployment of active duty armed forces in the foreseeable future, I think it will almost certainly happen under the Insurrection Act. I think that will be the tool that the administration reaches for. It's possible that the administration will attempt to use something I referred to earlier. It's called the protective power of the president, sometimes called the federal protective power. The idea there is that the president has an inherent constitutional authority to protect federal functions, personnel, and property. This is an old idea. It originates back in the 1870s. But it's never been squarely recognized by the courts, and it's never been recognized by Congress. It's really an executive branch theory. This theory doesn't itself grant any authority to federalize the National Guard, but it does plausibly authorize deployment of active duty armed forces in sort of potentially similar situations to which the Guard was deployed in the past year. There are a whole lot of questions hanging over the protective power, one of which is, does it even exist? And what is its scope? Is it an exception to the Boscombe-Thomas Act? Probably not. But that is a potential authority we might see the administration use, though again, it wouldn't be for the Federalized National Guard. I think it's more likely that if we see anything, it's going to be invocation of the Insurrection Act.
So,
And if I could say briefly, notwithstanding Martin v. Mott, there would undoubtedly be lawsuits filed. And I think that the takeaway from Trump v. Illinois, Newsom v. Trump, and Oregon v. Trump is, I think the takeaway is that the courts are going to dig into these questions. I think you're right. I don't think the courts are likely to dispose of these questions presenting these cases quickly in either direction. I think there's going to be sort of lengthy and thorough judicial review of these questions.
so you mentioned the Insurrection Act as one potential use. You also mentioned earlier that it has been more than a century since it's really been updated, and that maybe some of these laws have not been written in the best way possible. And so I'm curious, has there been any chatter about Congress doing anything to bring more clarity to these laws rather than just waiting for the courts to work it out?
Yes, absolutely. There has been more than chatter. In fact, there's been really a flurry of activity on the Hill in relation to these laws over the past year, and even going back further than that. I would say most significantly, Senator Richard Blumenthal of Connecticut has introduced both in the last Congress and then again in this second Congress a Insurrection Act reform bill. It's called the Insurrection Act of 2025, which is a complete overhaul of the law. And the goal of that bill is to sort of update the law for the 21st century. Again, this is a law that has not been meaningfully touched since 1874. Strip out the sort of archaic, vague language, and create something that will allow the president flexibility, because I think I think everyone agrees that the president needs to have flexibility in a real crisis. To preserve that flexibility, but to bring Congress and the courts in the process to act as procedural guardrails, and to ensure, particularly in situations where there's a kind of longer invocation of the Insurrection Act, that both the president and Congress are on the same page and are sort of united in agreeing that this deployment is necessary. And I think there is a bipartisan understanding in the Senate that the Insurrection Act is a problem. And it's a problem no matter who the president is. And I think that you will see at some point, I expect to see changes to the Insurrection Act. More recently, there's been congressional interest in changes to Section 12406. One of the simplest potential changes there is simply to repeal it. As I mentioned, Section 12406, it's not actually possible to interpret it in a way that completely makes sense. And it doesn't have a clear reason to exist, especially in a world where we have a reformed and updated Insurrection Act. So one fix there is simply to repeal it. There have also been proposals to make some certain changes to it. Various congressional offices have also, put forward proposals to strengthen the Paz Comptanas Act, adding greater, sort of more robust enforcement mechanisms to that law, changing its coverage, potentially adding a time limit to the invocation of exceptions to the Paz Comptanas Act. There's also, there's interest as well, and has been for a few years, in changes to Section 502F. But yeah, this is an area where, sort of big picture, the law is fuzzy and unsettled right now, and the law is probably also going to change in the next few years.
Kevin, my last question is going to be to you, but then we're going to open it up to the audience for questions. I don't know if we have a mic that we can pass around, but for people to at least start thinking of any questions they may have. So from both an operational and leadership perspective, what's the most important takeaway or recommendation for our audience on potential future deployments of Guard troops?
Yeah, I think the main takeaway that I would give you is reach out to your state National Guard and begin to make introductions. Know who their leadership is. Ask for a capability brief so that you know what they can do for you or maybe what they cannot. And then make that relationship kind of long-term. What you don't want to have happen is, and we've all heard this if you're in the emergency management community, I'm assuming in law enforcement and other elements of the federal government, but we don't want to be exchanging business cards and contact information when we're in the middle of an event. That is not the right time to do that. And so begin to make those relationships. I will tell you right now, we have a really good relationship with our office. Not only have they helped us with our incident response plan, not only were we a part of the collaborative effort with the governor's office and the National Guard with those Dropbox incidences, but our office has used the National Guard to assist us with doing penetration tests for our network since 2014. So we bring that capability in to assist us because on a daily basis, I average about 6,000 attacks on our network. And so we want to have that second set of eyes. So I think I have a pretty good idea of their capabilities. I know who their leadership is, but I also was a part of that organization. Those of you that have not, begin to reach out. They will love to talk to you. They want to express their capabilities. They also want to tell you when they can't help out. And remember, they are or should be your last resort because there's mutual aid agreements across the board, whether it's law enforcement, health, et cetera. All those mutual aid agreements should be expended before you reach out for that capability at the Guard level. But have that conversation now so that you're not doing it when it's confusing, there's chaos, and you're trying to answer the phone with 15 different individuals trying to get a hold of you. Make that relationship and reach out now would be my biggest takeaway for everyone in the audience.